Good afternoon. I'm Ted Novin, Director of Public Affairs at the National Shooting Sports Foundation, the trade association of America's firearms industry. We're here today to talk a little bit about the landmark decision that came down from the Supreme Court on Monday in McDonald v. Chicago. And joining me here today is the President and CEO of the National Shooting Sports Foundation, Steve Sanetti. Steve, thanks so much for joining us here to talk about the significance of this case.
Great being here today, Ted. It's a great day.
Well, and I should mention straight out that Steve is not only the President and CEO of the National Shooting Sports Foundation, but an attorney as well.
Guilty.
So we're certainly looking forward to getting your take on the significance of this latest ruling from the Supreme Court, both to members of the firearms industry and to sportsmen and hunters throughout the United States.
I'll try my best.
Okay. We also have, and I think this is important to mention, questions that were submitted from our Facebook and Twitter pages from viewers out there, and we're really looking forward to helping them understand this, and certainly having their questions is a great place to start. Probably, I guess, just starting off, talk to us a little bit about the case itself, McDonald v. Chicago, what it was about, how it started, and I think that's probably a good place to begin.
Well, I think many of the viewers know that Chicago has had a pretty draconian gun law since 1982. In effect, it's a gun ban for all handguns in Chicago and a virtual prohibition of long guns in the city of Chicago. Mr. McDonald is a 76-year-old who felt that he was the potential victim of violent crime in the city of Chicago and wanted to get a firearm for self-defense. Chicago's law absolutely prohibited him from getting a handgun and prohibited him from owning any long gun that hadn't been registered as of the date of the effect of the law in 1982. In effect, he couldn't own a gun. So he filed suit against the city challenging the law. It came up through the lower court system, and when it got to the U.S. Supreme Court, the question was, because the U.S. versus Heller case had been decided a few months ago, saying that the Second Amendment does give individual citizens the right to keep and bear arms as a fundamental right guaranteed by the U.S. Constitution. This case decided whether or not that right should also apply to the state and local governments as well as to the federal government. And they decided that it did.
So in Heller 2 years ago, that set up the right in federal enclaves like the District of Columbia.
Correct.
And now after McDonald, the question has been answered for every state and municipality in the United States.
That's correct. The court held that the Second Amendment guarantees the fundamental individual right of citizens to own firearms, to keep and bear arms, and it's a fundamental right that can't be abridged by federal, state, or local governments.
And is fundamental one of the key words? Does that equate the highest level of scrutiny?
Yeah, in lawyer talk, a fundamental right says exactly that. A fundamental right needs to be upheld, and any time a law is challenged as infringing a fundamental right, it's subjected to the highest level of judicial scrutiny. In other words, they look really carefully to see if the right is being infringed. That's unlike, let's say, a zoning ordinance where someone has a property right and they think a local zoning board may not have followed the correct procedure. Generally speaking, the courts, when they review that, will say, did that court just do what they thought was the right thing to do? Did they really abuse their discretion? And they tend to defer very broadly to the lower courts and lower administrative bodies. If something is a fundamental right, the burden is on those who would violate that right to really lay out a compelling case. Otherwise, the restriction is going to be overturned as violating a fundamental constitutional right.
Wow, so that's certainly a very significant ruling.
That's correct.
That came down.
Yes.
And this would actually be a good point to lead into one of our first questions from one of our viewers that came in via Twitter. Barry writes, will this ruling set the precedent to challenge any unjust laws? And he specifically cites, for example, the so-called assault weapons ban in California, or one gun a month laws that we've seen in places like Virginia.
Well, certainly it lays the foundation for a challenge. The court was silent on the breadth of the ruling, other than to say, as we've talked about, that it is a fundamental right guaranteed to individuals that can't be infringed by any government, whether it's the federal government, a state government, or a local city. They did not say anything in the opinion other than the fact that this particular ordinance that would block someone from owning a handgun for self-defense in the home is unconstitutional. And they left open the whole spectrum of what other gun control laws would be considered unreasonable as violating the constitutional protections of the Second Amendment. So yes, I'm sure this will be used as a basis to challenge laws, and I think we're in for a long haul, and these will all be decided on a case-by-case basis, but always under that strict scrutiny standard.
So this is really just the beginning. And now we have a fantastic foundation.
Right.
But it's really just the beginning, and we could be looking at challenges throughout the United States.
I think that's exactly right.
Wow. Well, Mike from Chicago wants to know that in lieu of the ban on handguns in Chicago, Mayor Daley has promised new regulations and restrictions. What effect would that have on the city of Chicago, and is there anything that could be done to circumvent that?
Well, it's ironic. I mean, every elected official takes an oath when he takes office to uphold the laws of the state or the federal government, depending on what position they hold. And yet you have officials here on the record in public statements and newspaper articles saying they're going to do everything they can to frustrate the supreme law of the land. I find that very ironic. That I think they're violating their duty as elected officials. That aside, you look at some of the restrictions that are being proposed by the city of Chicago. They want to require all firearms owners in the city to have large amounts of liability insurance. Well, we all know that liability insurance generally applies to accidents of various types. And firearms accidents aren't even 1% of the kinds of fatal accidents that you see in the country. They might as well require, if they really wanted to protect people from liability with insurance, they could look at swimming pools, bathtubs, ladders, all sorts of things that actually in the home create more of a liability than firearms do. Firearms are not the cause of the vast majority of accidents. That's one thing that makes no sense. One of the restrictions that they said is they want to require periodic retraining of firearms owners, which I find kind of strange because they're presuming that once you learn how to use a firearm, you're going to forget that you need to go back and be reminded and be retrained. It's like a driver's test or riding a bicycle. You don't forget how to use a firearm. It's a basically simple tool. Again, it's really done more to harass the legitimate firearms owner than it is to actually provide any safety benefit, in my opinion. Another restriction he's proposing is a limit to a total, not one a month, but a total of one handgun in the home, period. And that's all they would permit. Now, the decision says the right to keep and bear arms, plural. It doesn't say right to keep and bear an arm. So I think that's certainly subject to constitutional challenge.
Yeah, you would think this is a constitutional right on par with the First Amendment. Imagine if they tried to say, well, we have freedom of the press, but you can only pick and choose one newspaper.
Exactly. It makes no sense at all.
Yeah, there seems to be a disconnect there. Well, with specific relation to Chicago, and this might be too specific, but we'll certainly give it a shot. Kenneth wrote in, does this decision spell the end of the FOID card in Illinois? And is there any chance in the near future for people in Illinois to be able to carry concealed?
Well, I would refer to the answer we've previously given. Legislatures are still free to consider and enact various firearms laws, whether they expand individual rights to own firearms in the states or whether they feel that these are reasonable restrictions. The court left that question wide open. I think certainly the firearms owner ID card is going to be challenged. It's going to be a question of law and fact as to how the law is applied as to whether it's overturned. Concealed carry, again, is something that the individual states enact laws. They differ from state to state. As you know, there's been some movement to try to have uniform concealed carry laws around the country. So far, that's not gotten anywhere. But I believe now we're up to 48 states that allow concealed carry in some form. Illinois and Wisconsin are the two major standouts where it's not permitted. So I think if you look at the great body of what is now recognized as a right of law-abiding citizen under the regulations that each individual state may view as being reasonable, I think there is going to be a challenge that I think has a good chance of succeeding to permit citizens in all the states to be allowed to carry concealed firearms under whatever licensing conditions those governments enact.
And turning to maybe a more global perspective on this ruling, there's been a lot of concern, probably especially just over the last few years, about involvement of the UN on gun control related issues. Does this Supreme Court ruling, does this mitigate any larger UN threat with respect to gun control in the United States?
I think it does. The Constitution, the supremacy clause of the Constitution, says the Constitution shall be the supreme law of the land, and all laws and treaties are considered under that umbrella of protection that the Constitution guarantees the citizens of this country. So let's say that the United Nations comes across with some sort of treaty which, in some lapse of judgment, the Senate ratifies and says this is a treaty that we think is a good thing, and it bans the private ownership of handguns, let's say. Well, we now have the Supreme Court deciding that that's a fundamental right of American citizenship, and nothing should be permitted to abrogate the basic rights of Americans. The opinion itself recognizes that the laws all around the world differ, but under the American system of ordered liberty, that's a quote from the opinion, we have to respect the individual rights of American citizens to own firearms for self-defense. And I don't think, especially given this decision, that a treaty that would wipe that right out would ever be held to be constitutional, probably wouldn't get voted through the Senate.